Sego Sevaguego, Watpanuaradu Nui FNTV 360. We are broadcasting live from the Kahnawake Mohawk territory, and I'm Regan Jacobs.
I'm Lance DeLille. Now, for joining us, we have a special feature story to share with our audience today that will give a whole new perspective on planting.
But before we get to that, FNTV explores the recent decision of Quebec Superior Court Justice Thomas Davis, who declared that Kahnawage's Mohawk law discriminates against community members.
We need Corn Miller, whose husband is non-native, was the lead plaintiff in the case out of 16 individuals. FNTV had the opportunity to speak with Horn Miller and get her reaction on the recent court decision.
Well, the judgment that was rendered Monday was the case that we brought against the Mohawk Council of Kahnawake in 2013 regarding the membership law, or what they call as the Mohawk law, and challenged its whether it was violating our human rights. So the judge in his judgment really outlined that he understood sort of the historical reasons and whys that we've gotten to this situation we're in right now, and he I think it was pretty fair personally.
Like, ultimately, what did he say? Like, what was the outcome?
He basically stated that there are elements of the membership code that are unconstitutional and do violate the charter, but he did encourage that we have reconciliation within the community. He did mention that there were no mechanisms within the community in which anybody could give any take any grievances to, so there was really no option but to go to the outside court, and he recognized that. But he also recognized that there was a need to find resolution within the community, and he encouraged that.
In terms of what the all the members who were part of the lawsuit from Kahnawake were asking for, the judge did not give that in his final decision, but he did give an amount of $35,000. Can you elaborate on that?
Personally, this was never about money for me. But a civil case, in a civil case, basically what you're asking for is damages, right? That's sort of how things are shown if someone is found to be at fault, that the judge awards a form of damages. That's what a civil case is. So what I really got into this for was because I was watching things kind of unravel and get out of control, looking around and watching things get more and more kind of going towards violence, which I was concerned about. And I didn't see any institution in Kahnawake, anybody standing up and saying, no, this is not how we treat each other. This is not right. And what I really wanted, I really, really wanted people to stop and take account of how we were acting towards each other. And was this really a way in which our people, our ancestors, all of us, should be going towards our future, and that was my biggest wish.
Do you feel like at the end of the day that you accomplished the things that you wanted to, even with community members certainly not changing their mind, even with the outcome of the lawsuit? One
of the most important things that maybe it made us stop, and in the most important thing, stop and look at how we were treating each other, and just sort of that the environment of anger and violence. I also, people, the criticisms and anger right now, what? I look at this and I go, most importantly, this law, yes, I knew about it, but is it something that is indigenous and organic to Haudenosaunee people? No. Is it the way in which our ancestors taught us to survive? Absolutely not. It is something that has been imposed upon us by the Indian Act and is an extension of the Indian Act. And I believe that the only way that I could really start kind of getting it out of the fabric of our consciousness and our community is in the courts of the place in which created that act. I mean, this is something that is external. This is something that is meant to basically make us disappear. And if we continue to attack each other and continue to, see ourselves in only that kind of genocidal way of blood quantuming, we are really fulfilling the last phase of colonization. And we are going to do what the federal government wants us to do, which is basically destroy our power from within.
Speaking of reconciliation, because you talked about, wanting to move forward and putting some strategies in place there, how will you move forward, with regards to even being back in Kahnawake at some point? I don't know if that's in your future. I know you live away. But also, just reconciling with the community in any, in any aspect. How will you move forward? What does the future look like?
Personally, I always believe, I believe in contributing to my community, and wherever I am on this planet, I've always had that in my mind as an athlete, and now on the other side of my athletic career, trying to making more opportunities for our young people to participate in sport and make it more accessible.
The Mohawk Council of Kahnawake says they maintain their position that issues which are so integral to the community's identity have no business in outside courts. Here is a brief interview with MCK Chief Gasanahawe Sky Deer.
I think mixed emotions, but for the most part, I think we kind of had an idea that this is the way the judgment was going to go. But overall, we have to make it clear that the judgment does not mean that non-Indigenous people will be permitted to live in Kahnawake. That basically it was about the Mohawk people and how the membership law is set up to suspend or revoke certain entitlements and privileges. So that was pretty much the section that the judge declared inoperative. So, like I said, for us, I think the Grand Chief went on the radio earlier on this week and said, for us, it's business as usual. It's not as bad as we thought it was going to be or could have been. I'll go that far. Because originally they were asking for $800,000 in damages, and in the end, I think they were awarded $35,000.
I know that you guys, the Mohawk Council has been discussing the decision with your legal team, but do you guys feel that it could affect the membership law in any way?
All of the work that has gone into the membership law over the years from, 1981 to the current, it's not that the judgment declared that, everything has to be declared as, it's done, get rid of it, it's not good. There's a lot of components within the law, and, we've even tried to change the terminology, membership law. It's not a member, you're not a member of a club. That comes out of the Indian Act. So we said, we're going to change the title of this law to be Ganyagahaga of Kahnawake. So if you meet the criteria to be recognized as such based on your lineage, because as we know, it used to be a 50% blood quantum, which we've moved away from, and the community made that decision. The law is still going to be there. We just might have to do some tweaking and rewording so that it doesn't appear discriminatory.
The theories behind this Thomas Davis decision, that he said that it discriminated against Kahnawake members on the basis of family status or civil status. What are your thoughts on that?
That has long been, I think, a practice of people in the community who kind of wanted to have this penalization of fellow members. If you don't choose a Native spouse, therefore you're kind of violating Mohawk law, and then you need to have a penalization. And that penalization would have been suspension or a revocation of your entitlements to benefits and services. And that has been a long-standing principle, and the premise for it is that it's all about cultural preservation and about the identity. We've always said that the membership law, or the Ganyagahaga of Kahnawake law, is an exercise of the will of the people. So this is not an MCK law. We do not dictate, how this works. However, we can make recommendations based on the judgment to say, well, how could we make this in a way where it still maintains our position and our principles, but is not so blatantly looking like it's racism or discriminatory, because that's not the intent,
Mm-hmm. I know that the judge did talk about that, about how there was this stereotypical belief that non-natives would use up resources like the land or evading tax, if you will. Like, how do you feel about that?
Well, a lot of times that's what we see happens with individuals that get registered or now they're eligible for status under the Indian Act. They want that band card. They want their education paid for. They want the benefits and stuff that goes along with it without having any knowledge of their responsibility of what it means to be ungwehunwe or ganyagahaga and to, further our politics, our way of life. And there's a difference, a major difference and a distinction, and I think that's what the community has always been arguing, is that it should be our right to determine who we consider part of our community.
Now, you've been on, the membership portfolio for quite some time. What if any, what has been the reaction of community members in the last few days? Like, what kind of feedback have you received in your position?
Well, a lot of people I still feel are misinformed of what the judgment actually means. There's a lot of people that are very, very upset and angry, that this has happened, that they look at it as, why would somebody bring this to an outside court, to look at things from a non-native lens. I guess the sentiment is, how do you expect to beat the devil when the court is in hell, kind of thing. They're not going to judge against their own people, when it comes to non-Indigenous rights and about the charter and everything. And when we look at things from our own perspective about our what's in our circle, so to speak, our language, our culture, our identity. When somebody chooses outside of that, that's why they said, well, you go where they come from, go to where the non-Indigenous person lives, because then you bring their mentality, their government, their thoughts, their ideas into our canoe, and they don't mix well. It's very different. So like I said, there's a lot of people who are very upset and angry right now, but they don't really understand what it means. Like, they think that now that we've lost, that's kind of the key word that they all hang on. Oh, the MCK lost its case, that now non-natives are going to be permitted to live here. The membership law is kind of like scrapped, and all the work and everything we fought for is done, and that's totally not the case. And I try to reassure some community members that it's not as bad as it could have been. But as the Ganyagahaga of Ganawage, we are going to stand firm in our position, because we know we have a responsibility and a role to protect for the next 7 generations and ensure that all of the things that we benefit from are going to be here for them.
Lawyer for the plaintiff, Julius Grayson, in a National Post article that he's optimistic that the ruling could lead to reconciliation.